What is the history of abortion laws? Have you ever wondered how abortion laws have changed over time? The history of these laws is a fascinating journey through ethics, morality, and societal norms. Let's take a closer look at how we got here. In early American history, abortion was not criminalized before what is known as quickening, which is when fetal movements can first be felt, usually around the second trimester. During this time, laws were more focused on protecting women's health than outright banning abortion. For instance, in 1716, New York prohibited midwives from performing abortions, marking an early attempt to regulate reproductive care. As we moved into the early 19th century, some states began to take a stricter approach. Connecticut became the first state to regulate abortion by statute in 1821. New York followed in 1827, criminalizing post-quickening abortions as felonies and pre-quickening abortions as misdemeanors. These early laws aimed to protect women from unsafe procedures rather than to ban abortion completely. However, between the 1860s and 1880s, the landscape shifted dramatically. By 1880, many states had outlawed abortion at all stages of pregnancy, imposing criminal penalties on both providers and women seeking abortions. The American Medical Association, founded in 1847, played a significant role in this shift. The organization, dominated by male physicians, sought to establish authority over reproductive health, marginalizing midwives and nurses. The push for criminalization was influenced by ethical views about the sanctity of fetal life and the role of women in society. Laws reflected a moral stance that prioritized fetal protection while often disregarding women's autonomy. This led to unsafe procedures, primarily affecting poor women who lacked access to licensed physicians. Wealthier women could sometimes obtain safer abortions through sympathetic doctors. In the mid-20th century, the consequences of illegal abortions became a pressing public health issue, with high rates of complications and maternal deaths. This prompted a reform movement in the 1950s and 1960s, advocating for legal access to abortion as a matter of women's health and rights. Medical professionals began to argue that decisions about abortion should be made by physicians based on health considerations rather than criminal law. The landmark 1973 United States Supreme Court decision in Roe v. Wade marked a turning point. This ruling decriminalized abortion nationwide by recognizing a woman's constitutional right to privacy in making decisions about her pregnancy. It established a framework based on pregnancy trimesters, balancing the state's interests in protecting fetal life with women's rights. Since then, abortion laws have continued to evolve, with ongoing ethical debates about the moral status of the fetus and the role of government in regulating reproductive choices. Understanding the history of abortion laws through an ethical and moral lens reveals the tension between protecting potential life and respecting women's autonomy. This history informs contemporary discussions about reproductive rights and emphasizes the need to consider both the moral status of the fetus and the ethical importance of supporting women's health and decision-making capacity. The journey of abortion laws reflects changing societal values and the complex interplay of ethics, morality, and law.